Okay, so countries belonging to civil law traditions, such as Thailand, have adopted many Roman law principles. However, there are also frequent differences between current civil law systems and old Roman law. Please name and explain three such differences and discuss what the reasons for these differences might be. The first one is the fact that they said old Roman law. So we can say that it is a fact of codification. So basically, the corpus juris civilis, whether it is like so in terms of this, I'm just gonna say CIC. Was it before the CIC or was it after the CIC? And I believe the Ajans left us room to interpret whether it was before or after the CIC. So basically, I'm gonna say the first reason would be codification. I don't know if that spelling was right or wrong. And the second one would be in terms of commercial law. So basically, now it is not exclusive to, not exclusive to only private law. And for the reasons for codification, you can say that like current civil law systems after uh like you can elaborate on how like Justinian the First compiled all the legal sources within the Roman Empire, the digest and such, how it was discovered, to go to the root of the answer. That's one thing, and not only exclusive to private law. You can say that within modern civil law systems, civil law is also now includes like public law, public, also like commercial law, and uh, a little bit, a little bit. You can also talk about the development of like canon law, add in development of canon law. So basically, after the fall of the Roman Empire and after the compilation of the Corpus Juris Civilis, there was a vacuum of power. Therefore, the the church came into power, and therefore there was canon law, and the canon law was not as complicated as the Roman laws, and it basically was in place of the vacuum of power. And then later after that, the digest of the Corpus Juris Civilis was found again, and you can go on saying that like after the digest was found, it was combined with the Corpus Juris Civilis in the sense that uh, the digest was combined with canon law because of the fact that Roman society was already very developed, and their legal understanding and uh, their legal their society was already so complicated, so it was simply just adopted with canon law, and then commercial law came in to fill in the gaps of Roman law. So there was also that, and uh, for the third answer, I would say it is a matter of um. So we have codification not it only being exclusive to private law. We can also add in the fact of torts and obligations being taken seriously. So one aspect of this would be that they did not uh so not this is not like a main point. The main point would be that there was no distinction between no distinction on the oof, on the levels of liability of people. So basically, like there was no distinction in the sense that um they will they will physically bind you to the law by literally tying you to a tree if you do not did not do if you failed to do some sort of obligation. And yeah, that's all that I could come up with. And like you can add on to the third answer in the sense that right now we see that there are different levels of liability and different levels of prosecuting a person. There is the fine, forfeiture of property, and then the confinement, imprisonment, death penalty, blah 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 blah. So there is different levels of criminal liability. Back then, if you were to forget to do a obligation, or if you did not do an obligation, there is no segregation of liability. Rather, you were just tied to a tree. Right now, we feel the obligation to be to uh sorry, not the obligation, but we are legally bind to something, while back then uh, they were physically binded. So you can add that. That's my first answer to the first question. Jesus Christ, that's a lot. Um, Explain how the early period of common law's development has left its mark on the private law of today's common law system. So first, we have to know that within common law, there is no private law. Private law. So there's no private law in today's common law, nor in common law back then. So I believe this is kind of a trick question into making you show your understanding of common law. And within common law, there is no private law nor public law. Rather, you have to explain the writs, system of writs, system of writs, and how within the system of writs, you there was only the like there are only types of writs which concern the the affairs that were mainly the affairs that people would have, or just problems that people would have back in those times, right? and it and the only segregation between within common law back then was between whether or not it was a case of land or not land, that land or not land, or not land, like basically whether or not it was a case of property. And so it was very restricted in the sense that uh, the system of law you cannot just simply go into the court. You have to get a writ first. And even right now, I believe that within common law, there is no private law. Yes, yes, I believe. I think I'm not sure about the scope of where I have to answer, but what I believe is that should be somewhat of a elaboration on the system of writs, and that a emphasis on that there is no private law within common law, nor is there any sort of private common law did not develop from private law. Rather, it developed. Oh, okay. So it's asking for the development of private of common law. So you could say that private law did not develop from. Sorry, common law did not develop from private law. Rather, it developed from the fact that there was a need to solve issues, and these issues were solved by a system of writs, and then and then it will eventually go to court, and if it needs to go further, it goes to the king's court. Blah blah blah. Yes, I will not be going much into detail, but um yeah, because this is like the general scope of the answers, and I believe you can do further reading yourself. um Question 3, yes. Please describe the sources of law in the Thai legal system according to Section 4 Thai Civil and Commercial Code, and whether Supreme Court judgments are a source of law in the Thai legal system or not. This is quite a simple question. Basically, sources of law, Thai CCC. So sources of law, and there are 3, which is written, custom, customs, and section 4, written custom general principles. And there are also 4 ways to apply the law, which is written law, and then method of analogy, which is going to another body of law to find similar provisions and apply it to the case, which is just going back to written law. Therefore, that's why it's not counted as a source of law, because it is just written law. You can add that, but it's just the addition of analogy, or else the process is still the same: written, analogy, custom, general principles. I believe we can answer that quite okay, I think. And then the Supreme Court judgments, that's like another part of the question. So in terms of Supreme Court judgments, I believe you can go 2 ways. One can say that, oh, civil law country, but you should keep in mind that this is still an ongoing and debated issue. So there's no direct nor concrete answer to this. It's just that you can go either way, I believe. Yes. So civil law country, crunchy. Sorry. Civil law country, road, take me home to the place. So I just wrote county. I believe that is how you would spell country. I'm just gonna rewrite it again because that does not look nice. Okay, civil law country. So basically, in civil law country, since not common law, so court judgments are not a binding precedent. Therefore, So the Supreme Court judgments are not a binding precedent due to the fact that we are a civil law country, and thus previous judgments cannot be used on current judgments. Um, and there's more to add. Hold up. So the Supreme Court judgments are a source of law in the Thai legal system. Um, 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 um. Yeah, civil law country, not a common law country. And oh yeah, and that courts, lower courts that are lower than the Supreme Court are free to make their own precedent. To make their own judgment on similar cases that the Supreme Court already gave a ruling on. That's one answer. That's one way you can go about this. The second way, or the second way one can go about this is by means of um yes, the customary law, right, or route, customs route, as I would like to call it. USTOM. Yes. I think that's how you spell it. Route. Right. So the customs route is basically where you go from the perspective of that since Supreme Court judgments were used again and again and again, since these Supreme Court judgments were used as a precedent by the lower courts again and again and again, this can be seen as a source of customs, as an aspect of customs are the fact that the customary practices are done again and again and again, and eventually it becomes a source of law. Therefore, according to Section 4, Paragraph 2 of the Thai Civil and Commercial Code, it can be said that the Supreme Court judgments are a source of law because they are practiced as customs by lower courts. Okay. Okay, so, that's question 3. Question 4, Section 150, Thai Civil. Is that all? Oh, that's all. Yeah. Section 150, Thai Civil and Commercial Code provides an act is void if its object is expressly prohibited by law or is impossible or is contrary to public order. Ooh, or good morals. Ooh, arbitrary words. How do we know the meaning of these words? Okay. So Section 559 of the Thai Civil and Commercial Code provides, if no time for payment of rent is fixed by the contract or by custom, ooh, the rent must be paid at the end of each period for which it is stipulated. That is to say, if a property is hired at so much per year, the rent is payable at the end of each year. If a property is hired at so much per month, the rent is payable at the end of each month. In terms of relationship between customs and written law, please explain the existence of customs in 150 and 559 of the Thai Civil and Commercial Code from the perspective of legal provisions. Please also analyze whether the existence of customs in both legal provisions are similar or not. Okay, so within Section 150 of the Thai Civil and Commercial Code, it is said they added the fact of public order or good morals. And from the perspective of legal provisions, these are hold on. I would need some time because I just learned this literally not so long ago. Public order or good morals. So from the aspect of legal provisions, so this is connected to yes. So this from the perspective of legal provisions, customs. The word customs or words that have a very very general meaning will be added within legal provisions to provide will be added within legal provisions to oof contrary to public order or good morals, right? These are words that are very general and they provide a sort of hmm, Ah, it provides the court or the judge to look at the context of each cases where the law is applicable. Therefore, it doesn't. Uh, it gives the judge on the different. It gives the judge. It gives the judge like room, sort of like a space to sort of decide based on the context of each cases, and therefore these very general words are used within section 150, like public order or good morals. We will know we don't know what public order or good morals is. Rather, it is just inherently believed that we know what public order or good morals is. What good morals are. Jesus Christ. All right, if no time for payment and in within section 559, contract by custom. So since and this is also like the word custom was mentioned inside here, therefore the according to the mind map, it's going to be like the relationship between customs and written law from the perspective of legal provisions, and then uh, like the word customs or like synonyms to customs appear within the provision itself, meaning that the these the customs and written law relates in the sense that customs the word the words that have a general meaning appear directly, or the word customs appear directly within written provisions in order for court judgments to look at the context of each cases and give a judgment from the perspective of a reasonable person, or just like a normal person, just yeah, yeah, legal provisions. And the existence of customs in both legal provisions are let me just read it again. If no time for payment of rent is fixed by the contract or by custom, must be paid. Um, yes, I believe that the existence of customs in both legal provisions are similar in the sense that, like literally just what I said, are similar in the sense that they contain broad terms that can be interpreted in many ways, and therefore it can be used within different contexts that where these laws apply. It gives the judge to give a judgment based on the context, therefore protecting the people who are convicted of these laws in a way, um, although they are somewhat also different in the sense that if no time for payment of rent is fixed by the contract or by custom, the rent must be paid at the end of each month. Da, 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 da. So, um, oh wait, no, they're not different. They're both the same. They're both the same. They both have the idea. They both hone the idea of hmm, mm, Oh, they both have the idea of what is intrinsically believed by you as a person. Yeah. The existence of customs in both legal provisions are similar. Yeah, I believe that that is how you would answer these questions. I am. Custom the rent must be paid at the end of each period for which it is stipulated that is the safe of person. Yeah, yeah, that's pretty much it. All right, thank you very much.